Welcome to the Personal Injury Law Show, viewers. This is a show that talks about anything and everything to do with personal injuries, car accidents, work accidents, slips and falls, public liability. My name's Tony Carbone, personal injury lawyer of over 25 years' experience. With me tonight, I've got the specialist in work cover, John Karantzis. Good evening, John.
Good evening, Tony. Good evening, viewers.
And also Nunzio Tartaglia, the youngest insurance partner in the law.
Evening, John, Tony, viewers, welcome.
I think you are.
Could be.
Well, viewers, we'll see what's in the news.
John, what's in the news is this ongoing story about Craig Thompson and him spending money on escorts and the report of Fair Work Australia.
It's a shambles, it's a disgrace, Tony. What's going on here?
Well, look, what he's saying now is that he's been set up, Nunz.
Look, he's denying now the allegations have been set up. Look, the reality is
How do
it
you get
will come
set
out.
up to get escorts?
Well, that's what I'm interested to find out. And look, this Fair Work Australia report, as John said, 1,000 pages long, is not helping him.
John, he says that the union set him up. I don't know how you can set someone up in these circumstances.
Well, look, there's allegations made against him by Fair Work Australia. It's a report of over 1,000 pages. All these allegations regarding sexual impropriety, issues, allegations of fraud and misuse of the union credit cards, $70,000 between 2002 and 2007 spent on fine dining and motels.
Well, John, what I think is even more mischievous is the government's paying him his legal bills because they want to make sure that they don't lose his vote, because if he becomes bankrupt, he cannot vote.
But it's a double-edged sword, though, Tony, because if he does, if those allegations are founded, the government's going to look like an absolute clown.
Yeah, well,
it's not a good look. It's not a good look. Look, the Victorian and New South Wales Police are investigating the matter at the moment. Tony, in the end now, it's in the hands of the law.
Geez, they've spent a lot of money on this, haven't they? Yeah. The report's over 1,000 pages.
It could be jail time, Tony. That's the scary part about this.
And Tony, there will be more to come out.
Yeah, I'm pretty sure. Look, we'll deal with this story in the future. Look, the other story I want to go to is the young man that was belted at the 21st Century nightclub in Frankston, John, and he hit the ground and he died. The parents brought an action for nervous shock against the bouncers and the club. What happened, Ross?
Well, it went to verdict, and the judge found in favour of the two parents who sued on their deceased son's behalf, and found for them in the sum of $350,000, which is quite a considerable sum. Look, you know, he was king hit and died on impact. So
but the $350,000, once you
half each.
Half each.
Half each, $175 each.
But John, the maximum you can get under the Wrongs Act is only $371,000.
Yeah.
So the judge has given them a substantial verdict, really, haven't they?
Oh, look, I think so in this
And
case.
it's a very unusual case, Tony, isn't it, in the sense that we've got, look, a great judge, Judge Frank Ciccardo of the County Court of Victoria. He understands what this Greek family has gone through, and he's awarded a sum of damages regarding nervous shock, Tony, which is very unusual, isn't it?
And the judge, apart from being a very eminent judge, he was also a very eminent barrister at
he was.
QC. So
look, he's had a great resume.
Tonight, viewers, our topic of discussion is excursions, camps and the liability of unincorporated associations as distinct from incorporated. The first matter we're going to go to is this young fellow, Francis, who died when he was given a food ration with peanuts in there.
Yeah.
Just on that, there's a film clip when this matter was investigated by the coroner. I think we should go to that and then come back.
The Francis family sent their son to Scotch College, believing it would keep him safe. But they've spent 3 years searching for answers over his death at a school camp. Nathan was at a Scotch College Army Cadet camp when he ate a beef satay ration and collapsed. He'd had an allergic reaction to peanuts in the satay. Because of the camp's remote location in the Wombat State Forest, it took 2.5 hours to get him to hospital. Nathan was pronounced dead soon after. Today, as the inquest into his death began, a statement from the college principal was read in court, apologising to the teen's parents for the failures which contributed to his death. Scotch does acknowledge it did not do everything right by Nathan. The coroner heard Nathan's allergy to peanuts was noted on a medical report before the camp. An earlier probe was told medical reports weren't passed on to staff at the camp, and as a result, 3 boys allergic to peanuts were given the satay.
Nunzio, what did you get out of that?
Oh, look, it's just a sad case of events. You know, Nathan Francis goes to a school camp or a cadet camp, there to have a good time and learn and develop. And The camp were on notice about his allergies. Mum had written to them saying, look, he can't eat peanuts. He's got an allergic reaction. Because of their lack of systems in place, he's dead.
How does the school not make it common knowledge to the people that are providing the food that he cannot touch peanuts?
In one sense, Tony, I think we've got a case here of almost simple administrative error, Tony.
Sounds like total incompetence to me.
Well, yeah, also, we've got a very eminent private school here, Scotch College in Melbourne, situated in Hawthorn, Tony, your beloved football team. Now, they're a very,
We've got nothing to do with this, by the way.
No. Private school. Now, as part of the school curriculum, the students go on a school camp. Now, they've gone on this school camp, and before it's occurred, the mother has telephoned the school and said, my son...
And written in as well.
And written, my son is allergic to peanuts.
Look, this was the subject of proceedings by Comcare against
the Commonwealth.
The Commonwealth.
Yep.
And what happened then, Nons?
Well, this was against the Commonwealth with respect to they're the ones that were organised the camp and had the day-to-day control of the camp. It wasn't against the school itself, but with respect to the proceedings against the Commonwealth, it was found that they breached Section 16 of the Occupational Health and Safety Act, in which they failed to, ensure that he wasn't provided any peanuts, and which caused his death. And they'll find $210,000,
Yes.
which is quite a considerable sum.
Yes.
And the family, no doubt, John, would have a claim for nervous shock for wrongful death.
Exactly, pursuant to the Wrongs Act, yes.
I'm just astounded that something like this can happen in this day and age. Communication seems to break down a lot, doesn't it?
I agree. And what's worse, though, there's a case that occurred, I think, 2 or 3 years later, where basically similar circumstances, and even though they had a system in place, a kid still got allergic reaction to peanuts when he wasn't supposed to. It's crazy.
Peanuts and fish are two of the ones that have, people do react to, John. I mean, I had a client once that bought a hamburger and it was in the wrong pack, and as soon as the fish touched his mouth, he couldn't swallow and he couldn't breathe, so...
Well, in this case, it's a very sad situation. He's died within half an hour of having the peanuts, Tony.
They administered all sorts of medications.
Do you think the $210,000 should go to the parents?
Well, they've got their own claim anyway, not so. Yeah, anyway, we've got to go to a sponsors break, so viewers, please stay tuned. After the break, we're going to come back and discuss the Catholic Church and other unincorporated associations. Thank you.